I call Alfred Naro.
And I just want to respond to a couple of comments by the previous member. So, Mr Chair, we actually had 135 substantive submissions that were made. There were actually 98 of those submissions that were actually calling for a public register, 22 oral submissions in which we heard. The member made note about the fact of those who were victims, who asked for, those who were advocating on behalf of victims were, out of the 98, were asking for a public register. And there were those who were actually perpetrators and offenders who actually asked for that. Now, here's the reasons what the member actually didn't. He may have forgotten that some of the reasons why. When we think about those who are offenders, there's a continuum of those who've offended. There are those that are absolutely at the extreme end, who we know don't comply, who need restrictions and monitoring and management in their situation. There's also down the other end of the continuum, those, yes, who have made mistakes. You can also too think about the scenarios where there may have been an 18, 19-year-old who unfortunately may have had a relationship with a 15, 16-year-old. And it has happened, classified as statutory rape if there's a charge and a conviction that's held. So there's a continuum that we need to be aware of. In some of those submissions that were made, there was an offender who actually had said that he had rehabilitated himself, been many years without, he'd had a young family now, and was asking that there be some understanding for his situation. And that's the reasons why we need to be cognizant of the fact, when we think about a public register and the harm that it could cause, what about those who've admitted fault, who've had rehabilitation, but want an opportunity to make sure that their lives can continue on for them and their family? And that's part of the reasons why. The member then talks about, oh, absolutely, we're taking the victims into consideration. So here's the thing that the member also needs to remember, that this is not the silver bullet, as I know we've all been saying. In fact, what this is to enhance the CISO, which is the Centre for Impact for Research Sexual Offending, and this is where the police and collaborating with corrections have come together since 2013. What they've asked in this registration is to ensure they have up-to-date information. That's the power of the registration. It's not just a list of names. What that allows them to do is to put together what they call a product of intelligence, so that then when it comes to the risk management of an offender, if that information and that up-to-date data gives them the best possible ability to manage the risk. That's the reason why we have the register. That's what it's doing as well, and we think that's important. The member talked about the lack of evidence, and he's correct in saying that there's no comparative jurisdiction. In fact, in the States, there are multiple jurisdictions that are operational at that point in time. In other words, different correction departments, different police departments trying to work in different states. New Zealand is unique in that it has one jurisdiction. The member's correct. But there is evidence that states this, and it is in the departmental report, paragraph 21, and it states, there is, however, evidence that public notification can severely disrupt the life of the registered offender and their family, and thereby increase the risk of re-offending. So, we need to take that into account as well. I also want to then approach the member that if he reads on to paragraph 22, it also too, there is the largest and most comprehensive study about the impact of registration, which was carried out by Prescott and Rockoff, which talks about, we find the evidence that registration reduces the frequency of sex offending by providing law enforcement with information on local sex offenders. This is what we're talking about. This is what the register is about. This is what it's intended to do, Mr. Chair, and that's the intent of what it's actually trying to achieve. What it's doing, it's a register, along with those two enforcement agencies, to ensure they have up-to-date information, to ensure they have a product. And what that does, it creates a profile around certain offenders, which the member's absolutely right, needs to have some concern for our communities as well. Mr. Chair, I just want to comment on the cost. There's been some issue around the $146 million, and we did hear, and Mr. Clendon talked about the fact, police talked about, what that cost was to break down those costs. $5 million for, capital sort of setup of that service, around about $54 million over 5 years. But what they also told us, that 2/3 of the $146 million is already consumed in services, and also to intelligences that they currently have as well. So we're talking a portion of the $146 million that's already there, and all it's doing is actually pointing those services, in particular of intelligence, directly into ensure that the register is up to date and has information that's critically important. We think actually that's an appropriate use of that resource to ensure that we actually ensure that offenders are kept in line as well. Mr. Chair, I think I also too just want to make line that when we think about the register itself, Mr. Chair.
Potter Williams.